Hi, my name is Erich Straub, and I'm an attorney with Straub Immigration. And in this video, we are going to talk about immigration form I-9, and specifically, we're going to talk about how employers can prepare for I-9 inspections by the government. So first, let's talk a little bit about the Form I-9. And the Form I-9 is paperwork that every employer is required to fill out when a new employee is hired. The employer is also required to inspect certain documents, and those documents are to show two things. One, it's to show the identity of the employee, and it's also to show that the employee is eligible to work in the United States. Now, the real purpose behind the I-9 form and the whole reason that it came into existence was to prevent employers from hiring undocumented workers who were not authorized to work here. So this might seem like a pretty boring topic for a video, and you might ask yourself, why are we even talking about this? The reason that I-9 inspections have become so important is they have become the enforcement tool of choice by the government in terms of determining whether employers have hired undocumented workers. And so over the last 4 years, we have seen an increase every year in the number of I-9 inspections. As we've seen these inspections increase, the risks to employers have also increased, and employers need to prepare for those risks. And some of those risks are civil penalties, large fines that are associated with violations that occur on the I-9 forms. There can be criminal penalties if an employer is ultimately determined by the government to have knowingly hired unauthorized workers. And there are some practical consequences, particularly in the context of I-9 inspections, where a business can literally lose a substantial part of its workforce almost overnight. Now, before we go any further, I want to make two disclaimers about this video. Number one, even though we're talking about Form I-9s, this is about the inspection for I-9s and how to prepare for it. It's not a video about how to fill out the forms. There will be videos on our website, and I encourage you to go take a look at those videos about how to fill out the form. The second point that I want to make is that this video is for informational purposes only. And so by watching it, you do not have an attorney-client relationship with Straub Immigration. In order for us to form that relationship and in order for us to fully advise you, we would have to know the facts and circumstances that are specific to your case. So let's talk about the process of an I-9 inspection. And the process is probably going to begin with a visit to your business by an agent from Immigrations and Customs Enforcement, or what we like to refer to as an ICE agent. Now, the ICE agent is going to serve what's called a notice of inspection. And that notice of inspection is going to include a subpoena, which is going to ask you for certain documents. Those documents, not surprisingly, are going to include the Form I-9s that you have on your employees. It is also going to include a lot of business records. So having a law enforcement officer visit your business is never going to be a comfortable situation, and we're going to give you some tips on how to deal with that. One of the first things that we're going to tell you to do if you're in this situation is there is a 72-hour period that you have to respond to the subpoena. You should never waive that 72-hour period. It's also important to request that the officer go to a private area of your business to meet with you. And what I would suggest is that you do not take them to the same area where there might be business documents or I-9s that would be immediately accessible. If possible, you should have another person from your company present to witness the conversation that is occurring between you and the agent. Now, one of the reasons that you want the agent in one area is that you absolutely do not want the agent to be roaming around your business. You do not want them engaging in conversations with your employees. And in fact, legally, they cannot do that with the notice of inspection and the subpoena they have for an I-9 inspection. In order to do that, they would need a search warrant. And if necessary, you need to insist that they show that warrant to you. Now, you always want to be polite and you always want to be cooperative with the agent, but engage in minimal conversation. You should never answer questions at this stage regarding your I-9 forms and other business paperwork, about your employees or their immigration status, or about your employment hiring practices. You need to simply state to the agent that an attorney for the business will be consulted and will respond to the subpoena. So after the ICE agent has inspected your documents, you're going to hear back from them, and it's going to fit into one of two scenarios. One, they're going to say that you're in compliance. Now, quite honestly, in most situations where there is an I-9 inspection, that is not going to happen. The more likely is the second scenario, where there are going to be violations. And violations fit into two categories, either technical or substantive. Now, a technical violation is normally going to be an I-9 procedural error. The documents that were presented to prove work authorization usually are not going to be in question in a technical violation. So an example of a technical violation might be where the employee filled out the form but forgot to put their address or date of birth down. And normally, if technical violations are corrected in a reasonable time frame, a fine will not result and there is no criminal liability. A substantive violation, however, is more serious, and when you have a substantive violation, often the documents that were presented to prove work authorization are in question. And in that case, the government is going to have one of two responses. They may say that they're not certain, and they will give the employee an opportunity to present proof that shows that they are work authorized. In the second situation, they're simply going to tell you that they know that the employee is not work authorized. Now, where there is a violation, whether it be technical or substantive, the employer is going to have 10 days to take action to remedy that. Taking action either means that the employee has got to come forward with proof that they are work authorized, or it means that the employer is going to have to terminate them. So do you need an attorney? And the unqualified answer is yes, because it's important to remember that a subpoena is not a request, it is an order, and you are going to be required to turn this documentation over. It's important to also remember that there are risks involved here, that you have civil liability, significant fines, criminal liability that includes jail time potentially. And an attorney can help you navigate those risks in some very specific ways. So one of the ways that an attorney can help you is in the negotiation process. We talked about how, as an employer, you're going to be given 10 days to respond, and in many circumstances, an attorney can negotiate a longer period of time. They can help you mitigate the fines that might result from the I-9 inspection. And probably most importantly, as it relates to the negotiation process, you've always got to remember that the potential for criminal liability means that if you're directly communicating with the ICE agent, you are giving evidence that could be used against you in a criminal prosecution. And by having an attorney, you will shield yourself from that. The second way that an attorney can help you is with business contingency planning. So we talked about how ICE, in situations where they suspect that documents do not show work authorization, will request that your employees respond with additional information. And the reality is that in most of those circumstances, your employees are in fact not going to go talk to the ICE agent. They're simply not going to show up for work the next day. And that can be catastrophic to a business. An attorney can help you come up with a plan that minimizes the damage to your business and advises you how to execute that plan in a way that is going to limit future civil or criminal liability. The third way that an attorney can be helpful to you is in an I-9 inspection, you have to understand that this is not a one-time event. They are going to come back and do another inspection. And the second inspection may be, in fact, more critical than the first. It's important for you to get advice from an attorney so that you don't get into the same situation the second time. Because if you still have the same problems in a second inspection, you're much more likely to get substantial fines and an increased risk of criminal liability. At Straub Immigration, we have a reputation for achieving results in even the most difficult of cases. And whether your case turns out to be fairly straightforward or one of those difficult ones, I would welcome the opportunity to represent you.